get it. The OGs always told me what I start, I gotta finish. So I push it to the limit, so I can be the greatest. So I can look my family in their eyes and say we made it. Don't let life hand you nothing, you just gotta go take it. Always keep it 100, don't ever let me catch you faking. Keep a close eye on your circle.
Hey, y'all, and welcome to episode 2 of the Post-Prison Podcast, Pursuing Life After the Plantation. I'm your host, businessman, and entrepreneur, Darryl Riley. Joining me today, as usual, is my sister, friend, my homie, Miss Cynthia Brady. We also are being we're being blessed with the opportunity to have a special guest for the week. One of my main sheroes in my life. And if you don't have a shero in your life, I suggest you get one. Judge Sharonda Amamilo. Welcome, my sister, the first, not only woman, but the first Black Superior Court judge in Thurston County. Welcome, my sister. Proud to have you here, and even prouder to know you. As always, I like to start off with a little housekeeping, and that is to thank my team and everyone who's involved, from Cynthia to the production team, to the website people. You know, I'm proud of all of you all, you know, and it's nice when you get around people who are smarter than you. They tend to make you look a little better. So much love and respect to all of you all. Again, my name's Darryl Riley, entrepreneur and business professional. Cynthia Brady is a substance abuse professional in our community. And we like to start off by saying what we're not here to do. And that is we aren't here to argue. We aren't here to disparage. We aren't here to for any got you moments. We aren't here to attack. And I say this because we'll be speaking about a number of things that people have difficulty talking about. And we just want to come from that space to try to open up a window of opportunity so folks can draw from within themselves and find their own answers. Because my answers don't work. Your answers don't work for me, and mine don't work for you. We also are here to enlighten and inspire. That being said, we'd also like to ask you to continue to like and subscribe and share. A lot of you all have really supported us from the first episode, and I just want to say thank you from the bottom of my heart. So let's get into this. We'll start off. The title of this episode is Straight from the Judge's Mouth. And we're going to be having a discussion centered around a letter that was written by the Washington State Supreme Court. It was dated June 4th, 2020. And we've been sharing this on our page, but I think I printed it out because the letter itself is just so impactful. It just really done something for me as a Black citizen to hear the people who do the judging finally say they got it wrong. So the letter reads as follows. Dear members of the judiciary and legal community, we are compelled by recent events to join other state Supreme Courts around the nation in addressing our legal community. The devaluation and degradation of Black lives is not a recent event. It is a persistent and systemic injustice that predates this nation's founding. But recent events have brought to the forefront of our collective conscience a painful fact that is, for far too many of our citizens, common knowledge, the injustices faced by Black Americans are not relics of the past. We continue to see racialized policing and the overrepresentation of Black Americans in every stage of our criminal and juvenile justice system. Our institutions remain affected by the vestiges of slavery, Jim Crow laws that were never dismantled, and racist court decisions that were never disavowed. The legal community must recognize that we all bear responsibility for this ongoing injustice, and that we are capable of taking steps to address it, if only we have the courage and the will. This injustice still plaguing our community has its roots in the individual and collective actions of many, and cannot be addressed without the individual and collective actions of us all. As judges, we must recognize the role we have played in devaluing Black lives. This very court once held that a cemetery could lawfully deny a grieving Black parents the right to bury their infant. We cannot undo this wrong, but we can recognize our ability to do better in the future. We can develop greater awareness of our own conscious and unconscious biases in order to make just decisions in individual cases. And we can administer justice and support court rules in a way that brings greater racial justice to our system as a whole. As lawyers and members of the bar, we must recognize the harm that are caused when meritorious claims go unaddressed due to systematic inequities of the lack of financial, personal, or systemic support. And we must also recognize that this is not how a justice system must operate. Too often in the legal profession, we feel bound by tradition and the way things have always been. We must remember that even the most venerable precedent must be struck down when it is incorrect and harmful. The systemic oppression of Black Americans is not merely incorrect and harmful, it is shameful and deadly. Finally, as individuals, we must recognize that systemic racial injustice against Black Americans is not an omnipresent specter that will inevitably persist. It is the collective product of each of our individual actions, every action, every day. It is only by carefully reflecting on our actions, taking individual responsibility for them, and constantly striving for better that we can address the shameful legacy we inherit. We call on every member of our legal community to reflect on this moment and ask ourselves how we may work together to eradicate racism. As we lean in to do this hard and necessary work, may we also remember to support our Black colleagues by lifting their voices. Listening to and acknowledging their experiences will enrich and inform our shared cause of dismantling systematic racism. We go by the title of justice, and we are reaffirm our deepest level of commitment to achieving justice by ending racism. We urge you to join us in these efforts. This is our moral imperative. Sincerely, Deborah Stevens, Chief Justice, Charles Johnson, Justice, Barbara Matson, Justice, Susan Owens, Justice, Steve C. Gonzalez, Justice, Cheryl Gordon McLeod, Justice, Mary Yu, Justice, Raquel Montoya Lewis, Justice, G. Helen Whitner, Justice. Wow. So as we get into this, I'd like to start off, well, not start off, but I'd like to introduce Judge Sharonda Amamilo. And I'd also like to welcome Judge Sharonda Amamilo. Let me start by introducing you and letting you say hello to the people. Can you hear me?
I can hear you.
Okay.
Want me to go ahead?
Yeah, go ahead, please.
Sure. I'm Judge Sharonda Amamilo from Thurston County Superior Court. Before joining the bench, I was a career public defender, and much of what the letter from our current Supreme Court justices talks about really resonates, because those were the challenges I had to face as an advocate, not only myself, but also my colleagues, when trying to argue the objective and equitable administration of justice in cases involving my Black and brown clients. I'd like for, I've sent a short brief biography talking about my background and where I came from, as well as some of the work that I'm doing right now. I have, and Mr. Riley, I don't know if you expected me to read,
No, I'm gonna read it.
say what my background is, or were you expecting to read it?
I'm going to read it because I
Okay.
got some questions.
But first and foremost, I'd just like to say thank you very much for this opportunity to help carry forward the message of the justices on this platform, and to those out there who are seeking answers and wondering if that was a letter that's sitting someplace in just a nice trophy on a shelf for the justices to say they issued it, or have some judicial officers actually picked up the mantle to carry that message forward. And we'll talk about that later as we go forward in this interview, because I have some specific examples of things that I am specifically working on, and to show that I am committed to doing my part to carry that message forward. Thank you for having me.
Well, thank you, Your Honor. I'm glad you said that, and I thought it was in error not to read the bio first, but you kind of led me into it because a lot of your bio and where you are now talks about a direct correlation to the letter. So I kind of want to read that for everyone that's listening. Judge Sharonda D. Amamilo was elected to the Thurston County Superior Court bench in 2020 and began her historic first term in 2021 as the first person of color to serve as judge in Thurston County. She is committed to protecting the constitutional rights of all citizens, bringing a diversity of experience and background to objectively deliver compassionate justice to litigants appearing before the court, many with traumatic backgrounds. Prior to joining the bench, she served with the Thurston County Public Defense Office for 12 years, co-leading systemic change as a member of the management team from 2014 until her departure in 2019. She received her bachelor's in adult education from Southern Illinois University, McCord Air Force Base in 95, her master's in business administration degree from St. Martin's in 97 in Lacey, and her Juris Doctorate from Seattle University of Law. She is a retired chief warrant officer with the U.S. Army Reserves. Judge Amamilo's personality profile is an advocate, introverted, intuitive, feeling, and judging, INFJ. Her top 5 strengths are relator, learner, connectedness, strategic, and achiever. Judge Amamilo serves on multiple statewide commissions, work groups that address systemic changes faced by stakeholders and individuals involved in the law and justice system. The collaborative efforts include the Washington State Sentencing Guidelines Commission, the Joint Legislative Task Force on Jail Standards, the Alternatives to Incarceration Task Force, the Family Wellbeing Community Collaborative, and the National Judicial Network, Forum on Human Trafficking and Immigration in State Courts. She also actively served this community as a member of the American Legion Post 94 Lacey and Gateway Rotary in Thurston County. Judge Amamilo also sees herself as a servant leader, problem solver. And she's also a big supporter of most communities and an amazing organization called DADS. I'm going to throw that should be part of the bio as well, because that's powerful, the work you do there. But back into the meat of our conversation. That's a little different bio than you normally hear from a judge. It doesn't matter their color. And I've been before a few, so I'm kind of familiar with some of that. But as far as this letter is concerned, I'm going to pass it over to Cynthia and let her begin the conversation with a question.
Good afternoon, Judge. I am so honored to have you as a guest on here today. And after reading the letter, I want to say that I commend you for signing it and for acknowledging, what is wrong with our system. I would like to ask you a couple of questions, but I want to start out with asking you, what was the catalyst behind this letter? I mean, what was the urgency that June 4th, 2020, you decided to sit down and this letter came about?
Well, first, I want the record to reflect that all due credit goes to the current 9 Washington State Supreme Court justices that wrote that letter. And as a Superior Court judge, we are sort of the foot soldiers out at the trial level where most of this injustice that they speak of occurs. Because we are the ones in the adult felony court, in the juvenile offender court, we're the ones handing out these sentences and these dispositions that the letter really addresses from the court system, the disparate impact on Black and brown individuals. So first, I would say that the credit for that letter goes to our current 9 Supreme Court justices, and I am a Superior Court judge, which is 2 levels below. So we have the Supreme Court of the state of Washington. We have 3 different divisions of the Courts of Appeals. Division 1 is big counties, King County, Snohomish County. Division 2 is the South, which includes Pierce County and all the counties south here all the way to Oregon. And then out in Eastern Washington, they have Division 3. So that's the first thing to get the structure right. So when you hear them in that letter say, the expectation is that the judges and the attorneys and others in the legal community are to carry that message forward. And from the position that we're in, to carry out the spirit of that letter from what we can do, what we can affect. They are then giving me a charge as a superior court judge, and I'm at the trial court level. So that's the structure. The impetus was the George Floyd, not just the Judge Floyd event, but kind of like the straw that broke the camel's back. That the system cannot tolerate any longer the judiciary sitting idly by with pseudo clean hands, exclaiming that it is only responding to what is being brought to it. And we have to keep ourselves so separate and independent that we can't take a position on nonpartisan injustice or justice related things that are happening around us. It's as if we were not acknowledging that we are impacted and aware of the things that are happening in the community, that are happening to the people being brought before us, and then putting on blinders and saying, we can't look at that, or we can't consider that, we can't take judicial notice of that. We take judicial notice of lots and lots of things. We take judicial notice of legal precedent. We take judicial notice of other things that have been recognized as quote unquote common knowledge. But the topic that this letter addresses is common knowledge that we know, but we are not supposed to consider it because it may skew bias to treating Black and brown people differently. Yet, without taking that into effect and taking into account all other types of trauma aggravating and mitigating factors, when you have an over-policed population, we were treating Black and brown. We are treating Black and brown. The system, as a whole in general, still is treating Black and brown individuals, defendants, differently. And so I think they realized, and you have to look at the makeup of our Supreme Court bench as well. We have the most diverse Supreme Court bench in this country. That's why part of their letter says the colleagues in the judiciary who have a minority of peers, like me being the only one on my nine person bench. You have to listen to those voices and lift those voices up, because you will continue to do the status quo, which is what I will talk about later. But they will continue to do the status quo because that's what's comfortable and that's the culture of the system. So the answer to your question is they just couldn't take another hit, considering that our chief is the first Hispanic chief that we've had in the state. We have the first Native American, the only Native American in the country. We have two members of the LGBTQ plus community. We have a Black woman, and we have a white woman, and we have a white man. So we have a very, very
Diverse.
not just diverse, but representative Supreme Court here in the state of Washington. And it's just something to really, as a judicial officer, it's just something to be really, really proud of, that the people of the state of Washington, the governor and his appointments, and then the decisions that they have been making, and I hope I get an opportunity to talk about a few significant decisions that they have been making, really do afford the opportunity for everyone to get more of an objective and equitable, deliberation and consideration of their life and the impact of any decision on them when it comes before them. I'm really proud of our Supreme Court. So thank you.
Thank you. The second question is, what changes has been made or have they tried to start making to address those things that they talk about in the letter?
Well, I'll start with something called General Rule 37. You'll hear it referred to as GR 37. And it's a rule that probably was in place before that letter was written, but it's a rule now that we as trial judges dealing with criminal trials especially, and even civil trials, which there's a civil case that was really significant that came out recently within the last 30 days or so. General Rule 37 says the judicial officer and every other stakeholder, to include the attorneys, has an obligation during jury pool selection, has an obligation to be hypervigilant to folks who may
Mm.
be part of the BIPOC community in the jury pool. So there's different types of rights that you have in picking a jury, right? So you have peremptory strikes, and then you have other types of strikes that you have to, there are for cause strikes. So you get, there's some strikes of jurors that you get to make just automatically, no questions asked. And then there's other strikes where you have to essentially make the case of a hardship or too traumatizing for a person or something like that, based on the subject matter of the crime that's going to be in the trial. And then as you're going through this process, you really have to look out for people who might not otherwise be picked up. So the first thing we get is a list of names of the jury pool. So for example, tomorrow I may potentially have a criminal jury trial. There's going to be a jury pool. They're going to send me the jury names and their information sheets. And first thing we're scanning for is any names that might be names of a marginalized community member. That's the
Mm.
first thing we're scanning for. And then they're flagged. And then the next thing we're scanning for is anyone who may have had some experiences that might make them inherently biased, even if it's subconsciously, in their information, the limited information they provide in their juror questionnaire. And then when we bring them into the room, if their name says Bill Smith and we look at Bill Smith and he looks like Darryl Riley, he's going to get flagged too, right? You're going to flag him too, because we couldn't tell from any other thing that he might be a member of the marginalized community. So we have all of these, checkpoints now in the jury selection system pursuant to General Rule 37 that says there have been historically so much effort around strategically selecting jurors who may be already inherently biased against a defendant, that they are trying to put things in place to really eliminate that possibility. So then, if you were to challenge Bill Smith and he's looking like Darryl Riley, and then you say, I want to move to exclude, say you're the prosecution or the defense, they don't really care. I move to exclude Bill Smith. You're going to have to go up to the judge on the sidebar, and you're going to have to give them a very detailed reason based on some answer that Bill Smith gave that satisfies the requirement for creation of a very clear bias against either people like the defendant or people who have been accused the way the defendant has been accused. You're going to have a hard time excluding Bill Smith unless he does something to get himself disqualified. And so, as you can see, and that's the jury process. So that's the first step. Then there are other things that we hope to be able to do, and I'll talk about now some of the things that I have done. And it's wherever you are, right, Miss Brady and Mr. Riley. It's literally wherever you are, what you're able to do, and what your colleagues are comfortable with, because you're causing them to stretch a little bit too. So right now, we know at the federal level, and the federal level at the Washington District Court federal level, that's the same trial level as Superior Court. It's the same level. They're doing the same thing, same types of felonies, same types of complex civil cases, same thing, except for it's federal jurisdiction that those events happen. Well, in their system, there is no sentencing occurring without a sentencing memorandum, a sentencing package, information about this individual, particular to this individual, so that the judge can try and craft a sentence and issue a sentence that is more likely than not to resonate with that particular individual, to cause them to want to do things differently when they get to the other side of their sentence, to mitigate maybe and explain and put into context their behaviors such that the judge was, whatever the prosecution is saying about the person. The judge has some other information here that tells him this person has all kinds of trauma, and that throughout their life, at one point they may have been they may be a defendant now, but at another point they were a victim, and maybe through childhood and adolescence. In Washington State, we do not have a requirement for sentencing information at the time of sentencing, unless it is an alternative sentence. So if it's a mental health sentencing alternative, treatment versus prison, drug offender sentencing alternative, either residential, which is out of prison, inpatient treatment, or part of your sentences in prison and part of your sentences out of prison, or it's drug court alternative, or sex offender treatment alternative. So unless or family, you're taking care, you're the primary caregiver for your children, and you are getting a family offender sentencing alternative. All other things, there's no requirement, and I'm hoping to get to that on the Sentencing Guidelines Commission eventually. But no, all other things, there's no requirement. As a matter of fact, there used to be a Criminal Rule 7.2 at the state level. The main criminal rules are issued by the Supreme Court or approved by the Supreme Court. There used to be a Criminal Rule 7.2, which is what the judge should expect to receive at sentencing. But for whatever reason, that's just reserved now. It's just rescinded and reserved. It's nothing specific. So each jurisdiction can come up with their own. Well, Thurston County came up with a Criminal Rule 7.2, and it's just vague. It essentially tells the attorneys they can pick and choose to either to provide whatever they want or provide nothing at all. And most of the time, they just default to the RCW that requires that information about a person if they're going for an alternative sentence. So because it is so vague, I started interpreting it. So my interpretation is, when I'm covering the change of plea and sentencing calendar, I send an email. I have my judicial assistant send an email to the attorneys, and I say, these are the things that Judge Amamilo wants the day before sentencing, in accordance with the local rule that says any materials that the judge is to consider have to be on file the day before sentencing. So that's what I do, and I request the information, and that request is something that I've been trying to get them to do voluntarily since I got to the bench, which was after the letter. I need more information. I need to know who I'm talking to. I need to know how they listen. I need to know the traumas that they've been through, because oftentimes, if you really don't connect with the individual and you just send them off to prison again, if they got 5 points or 3 points or 2 points, even the first time, or 9 points for their quote unquote career issues, you still may not address the issue that is the most concerning for the victim who is most impacted, unless you know something about the person. So I'm thinking in my head, I'm getting information so that I can craft something so that I can connect to this person. They can relate to what I'm talking about. They will be encouraged and motivated to address whatever the behavior was that caused them to be before me. And the victim will have an opportunity to breathe a sigh of relief. Like, this person has this opportunity, because oftentimes we need to understand that victims know their perpetrators in most cases better than anybody else in the room. Right? Better than anybody else in the room. There's more often than not a connection when we're talking about crimes involving victims. In crimes that don't involve victims, their families know them, right? And so when I get a person in front of me and I don't even have a letter from their mother or their significant other or a person in the community, or even from themselves talking about their life, then I'm having to kind of pull a little bit, and draw it out a little bit and make everybody nervous, which I don't mind doing. Make everybody a little bit nervous, because I'm trying to make that connection. So I'm trying to get my colleagues to understand the importance. And that letter is actually a very is almost like a gift, because in that letter it gives me a tool. It tells my colleagues to listen and to lift up my voice. It tells my colleagues that the only way for us to do I guess to do right by, or to uh, seriously approach addressing the wrongs that have been the even if we just did it by the numbers, the data itself so justifies everything in that letter. If we did that, the only way to do that is to get more information, to be more informed. And last week, I guess it was just this Monday night, I went to a webinar, attended a webinar where we had the whole history provided to a about I would say about 20 judges, a mixture of Supreme Court justices, Superior Court judges, and municipal court judges, listening to a presentation by the Black Prisoners Caucus here in Washington, and how they really are laying out all the information that judges actually need. And they were telling the justices that. They were telling the Superior Court judges that. They're telling the municipal court judges that. This is the information you actually need to care about, so that when you're rendering a sentence, or you're reconsidering a decision that was made at a trial court level, which Supreme Court and appellate judges are, the division judges are appellate judges. When you're looking at that, you need to know, did the judge have enough information at the trial court level? Did they have enough information about this individual that they were sentencing? Because these people were presented to us because you turned our lives upside down in places and ways it wasn't even necessary. Because we knew we were going to do time, but the other things weren't taken into consideration. And it made it so much harder when we done our time for us to be better and to be able to reintegrate and re-enter and reintegrate back into the community in a positive way. Getting back up to speed is extra difficult, and it's more not seen any more pointedly than in the Black and brown community. They have the hardest, the data shows it's the hardest group to recover, even after they quote unquote pay their debt to society. The collateral damage is enormous. The collateral consequences is enormous. It takes a long time. So that's one of the things that I am doing. Individual judges, some of my colleagues are trying to do the same thing. The pushback is fierce from the field, from the attorneys, defendants, defense, and prosecution alike. So my colleagues have agreed, because I looked at them, and I'm an independently elected judicial officer. I can ask people for the information I need to make competent decisions. So my colleagues have agreed to meet here in the next few days, and we're going to sit down and talk about, okay, what do we want to say our local rule means? Because right now the litigants get to decide if we get any information at all. And that, to me, I know this judicial officer will not accept that. And they know this judicial officer will not accept that. I believe they understand why. It's not from any sort of power play sort of place. It's just that in my years of experience as a career public defender, to include my experience representing youth in foster care and representing juveniles in the juvenile justice system, and having to get to know people really, really well on their level, the way they understand the world around them and what they think they have to do to survive and to get to that next level of success. These are real experiences that I can convey to my colleagues. These are real experiences that I can connect with the individuals in front of me. And I do believe that they genuinely want to hear, because they do recognize that their backgrounds did not afford them the opportunity to know some of that stuff on a personal level. And just because you're presiding over cases, year after year after year, people come in before you who have those backgrounds. If you don't dig into them, you don't really know. You don't put yourself out there in other kinds of ways off the bench, you don't really know. So aside from using all the tools in my toolbox, I will use the tools in my toolbox. I do try, as Mr. Riley indicated, I do try to keep my finger on the pulse of what's happening in the communities. The Divine Alternatives for Dad services in Seattle literally is a place where I cut my teeth as a junior attorney, just going in there and just listening to those gentlemen. Working down here in Thurston County with the Family Education Support Services, Executive Director Shelley Willis, just really hearing from the people who are connected to the people most impacted. I think it's always important to do that. As an attorney, I volunteered with the programs committee, review committee for the Children, Youth, and Services here in Olympia, where we reviewed every single one of their programs on a quarterly basis to see if they were hitting their targets and milestones for families at risk and youth at risk, and other ways in which the the service providers and the social service providers in the community were collaborating together. So those are things that I do, and those are things that some of my colleagues do. Some of those committees that Mr. Riley talked about, those are multidisciplinary committees, almost all of them. I like working in collaborative groups and oftentimes helping people figure out how much common ground they have and how many tools they already have at their disposal that they're not using, which can propel them forward in the strategic goals that they believe they are pursuing. So
I was going to say,
doing that.
I was going to say, you using your toolbox and everybody else's toolbox.
I think it's important to help people be successful where they're at. If they're talking about if they think they're talking about the same thing,
Yeah.
and any way in which I can help encourage or help them hone those skills, and give them opportunities to apply those skills with the supports, whatever support that I can give them. I think in the end, I could be the shadow boxer all day long. It doesn't matter to me. I just want what's the right outcome. I'm just totally committed to that. That's my driver and motivator at all times. So I leave ego in the shadow. It's back there shadow boxing, I guess.
Well, first of all, the shadow boxing teaches you how to fight, number one. Secondly, I'll say for me, the letter kind of vindicated me in some cases, because sometimes I went to jail for something I didn't do, and there were so many holdback charges. You know how they play the game. So you have to plead guilty to those. You have to plead guilty to a prison sentence to end up getting caught up and get probably triple the amount of time. So I appreciate the letter in that aspect. I appreciate also getting the insight into the work that's being put into this, because I know from my experiences with you that you are going to play, and what you guys are doing is what we started talking about. That's how you dismantle those systems. The structures are in place, and you alluded to that. You still have those individuals who don't want to see that change, who don't want to move the needle. So kudos to you. I appreciate you, your compassionate approach. And it seems like the judges, especially Chief Judge Gonzalez, I met him before, seems like a very compassionate individual. And it just, most of the time when I don't know if Cynthia can allude to this, but most of the time when I went before a judge, they didn't really even look at me. They didn't even notice me. You know what I'm saying? Except when they want to stand on the court and do something like this and, demean me. And then you talked about people not having the needs met and then get out here and fall right back into the same traps. Well, that system kind of continues when you get out with parole and probation.
Well, something else she said, though, that was important was depending on where you're at, also was whether because she's saying basically earlier, she said that she gets a lot of pushback. Well, if you really pay attention, some of these counties are still doing the same thing they've been doing for years upon years and are probably going to continue to do some of the same things unless we can get people like her in place doing what she's doing, educating them, being the vessel, giving pushback, fighting, like you say, shadow boxing or whatever it is that it takes. I commend you, and I'm glad that you're in the position that you're in because your voice do need to be heard, and people need to recognize that that letter do exist. Because I didn't even know the letter exists until Darryl said something.
Well, I also want to ask your thoughts on well, I've been getting rumblings as a citizen about the Washington legislature and their attempts to move towards decriminalizing narcotics, to follow the steps of Oregon, if you will. Is the courts, are they being advised by that in any capacity? I mean, I know they don't have nothing to say with the legislator, but how would that affect you all and how you move?
Well, that is part of that. Something like that is part of the discussions at the Sentencing Guidelines Commission. We talk a lot about which laws are no longer relevant and should be repealed. We talk about which laws are improperly ranked at seriousness level as compared to other laws that are not ranked as high or low. And we talked about the likelihood of the higher ranking, serious ranking offense may fall more heavily on the BIPOC community, on Black and Brown defendants. We talk about all of these things, and on the Sentencing Guidelines Commission, if you were to pull up their website, which I would encourage your leadership, your viewership, yourselves and your viewership, to just put that on your website, and for people to watch the Sentencing Guidelines Commission meetings. You can listen in and watch us every month on the second Friday of the month from 9 a.m. to noon. It is an all-day session. And we're all morning session, I should say, and we're talking about those very things, like which laws and how are those things impacted. And as it relates to the drug laws, getting back to the original question, those representatives, the legislative representatives, are in the room. And so we are providing advice and guidance to them. If they come to recommend a new law to criminalize some new behavior, we part of what we do is tell them where it may already exist, and there may be no need to create a new law. And they might propose legislation. We get to review that and determine whether or not it needs rewording. And so we talk about what's the fallout if this law goes into effect. What is going to be the impact on the trial judges? There's at least 3 trial judges on that, if not 4, I think, on that commission. And we're talking about exactly, well, how we're going to enforce that, or, exactly how is that going to come before us, or, is that anywhere else? And we're talking about how we're going to monitor. So I think, and then it also, if that law goes into place, what community is going to get hit the hardest? How hard is law enforcement going to work to really find out, right? So we talked about drugs on the street a lot, on the TV. They talk about the drugs on the street a lot. I listened to a TVW broadcast today that was talking about the increase in crime and the increase in violent crime. And generic statements like that mean nothing to me. They just go like that. They mean nothing to me. Let's be specific. What crimes are you talking about? In what communities are you talking about? And do you have policing anywhere else? At the same level, right? And I think when we talk about drugs, why do we start at the street? I don't understand. Why do we start at
Bottom
the
up.
street?
The bottom up.
The drugs are brought in by planes and trains and boats. Why do we start at the street? The people on the street do not have planes and trains and boats and big semis and elaborate um, mechanisms at the border. Those are not the. I get flummoxed every time I hear a high level conversation of people talking about what are we going to do about the drugs on the streets.
Well, that's kind of
Because
that
that's not
that's
where the problem
yeah
begins. If
yeah.
we want to be really serious, we have about the drugs on the streets. We have to talk about millions and millions of pounds or tons or whatever. We have to talk about what kind of system does it take to get that amount of drugs on the streets into to your street in your neighborhood.
Well, in some cases, in one in particular, well, in two in particular, if not the government entities were involved. The Iran Contra affair was about drugs, and there's an
Well,
article about
I want to make it very plain. I do not know where to point a finger.
yeah.
I do not know where to point a finger because in my role, I'm dealing with the people in the that they interface with on the street, right? But when I'm sentencing that person and that person in front of me, and I get nothing but the blurb of the dangerousness to the community.
Yes.
If we don't do this, if the court doesn't accept this recommended sentence, um, the dangerous to the community is going to be X, Y, and Z. Um, and this person is not going to get the help they need unless they go to prison without any representation about what exactly they have access to in prison. And I've learned in the short time that I've been a judge that when people go to prison with long sentences and they have addictions and other types of challenges, they're not even going to get anything but time until just before it's time for them to be released from prison. And they will be lucky to have avoided the in prison drug uh, community to support their addiction
Yeah.
while they're in prison.
Yeah, many of my clients tell me that if I wanted to get high, I could have got high in prison. So,
Right.
so I understand it. Being a substance use counselor, I hear all types of conversations concerning them being able to get high there or not being able to get the help they needed while they were in there, or the program was based on uh them being able to stay clean and sober as long as they were in the program inside the prison. But once they walk outside of there, it's when they face a lot of the challenges. And what I
And, and I would
commend something you said
and I
about
would say, Miss
knowing their
Brady.
story, knowing their story, like knowing something about them.
Mhm.
I think judges need to know something about the people that's standing in front of them more than their number, the federal number they gave them, and the crime that was supposed to be committed. They need
That's
to know.
very important, Miss Brady, and that goes back to the multidisciplinary work that I do. I really enjoy it because I like to know where I can do warm handoffs, right?
Mm,
When people are challenged, say I'm giving a sentence for credit for time served, and part of the judgment and sentence requests that I impose a, a substance abuse evaluation and follow recommendations or a mental health evaluation and follow recommendations. I want to know what the parties have done prior to coming to ask me to impose this sentence to set that person up for failure. Is the evaluation already done? It could have been done in custody. They do it all the time. Is there,
Absolutely.
even if it's not been done, is there appointment already made? How about we, because those life domains, right? Where you're gonna live, are you gonna be safe if you need treatment, a treatment-based judgment and sentence, to the extent, to the degree that we can do warm handoffs in any way to alleviate some of the instability that the person is going to return to. I think we have an obligation, as Ms. Brady said, knowing something about what who the person is will give you a lot of insight as to what the person's needs are. And with my background and experience, I understand a lot about what helps people want to stay on the right track, because the internal motivation, we have to try our level best to support and encourage and set them up for success from an internal motivation perspective.
Absolutely.
So thank you.
Well, Your Honor, I'd like to touch on just two more quick topics before we let you go. We appreciate your time. I'd like to ask you, most of our conversation has kind of shifted from just the focus on the letter. We're beyond that, talking about the intricacies now. What I'd like to know from you is, how has the Blake decision affected all of that process? And for those of you unaware, the Blake decision is a new ruling that just recently came out in 2021 that ruled that the felony possession law is unconstitutional.
Yes, the Blake decision, literally, when you're talking about throwing a monkey wrench into the system, that was a literal monkey wrench. So many people were in jail and in prison on simple possession of a controlled substance. And so people think that, oh, the Blake decision came out, and the court determined that the law was unconstitutional, and the DOC or jails, they're just going to open the floodgates and let them out that day. That did not happen.
No.
That did not happen. What had to happen is coordination had to happen, and motions had to be filed in all the places around the state, and all the jurisdictions around the state where people were serving time for those convictions. So the focus at first was on the getting the people in jail out first, who could be instantly released. But no consideration was given to whether or not that would ultimately end up with a disparate impact on the BIPOC community, because we know that non-Black and brown folks get less time in the first place. And so, and they often don't get just when they get charged with unlawful possession of controlled substance, they didn't often have just a singular charge. So no one looked at whether or not, and I'm not saying that there was a disparate release of the number of non-Black and brown people that got released, but I just want the world to know that no one was instantly released. They still had to go through the court process. What has happened secondly is called Blake resentencing hearings, when people have multiple convictions on their JNS that they're serving, and the Blake decision changes their offender score.
Yeah.
Then they have to be brought back to court to see whether or not there's going to be a change in the range of sentence, and or should they just be resentenced altogether. So a lot of litigation around whether or not if they get resentenced altogether, if they're resentenced altogether, and this goes back to Mr. Riley's observation about how there could be charges in the background if he's pleading to one thing. If the defendant wanted to be resentenced altogether, then the prosecution wanted to rescind the plea agreement and maybe dangle the threat of some of those things hanging out in the background that weren't charged before. So there's a lot of litigation around it. There's not a lot of appellate guiding case law that has come out about how the person either gets to, if the person wants to be resentenced from scratch on the pled to charges, convictions, then the judge, if everybody agrees to that, the judge gets to sentence them from scratch and consider all of the mitigating or aggravating factors appropriate at the time of sentencing. But if there isn't an agreement on what the resentence should be,
risky.
Yes, it's very risky.
Very risky.
Because the other side can say, nope, the whole thing is out, and we're either gonna plead to leave it alone and we're going to come to an agreement, or the whole thing is out and we'll be pleading all over again. So there's a lot of litigation going on.
That's like playing Russian roulette.
Well, Your Honor, I really appreciate you. I saved this question for last because I know you had a lot of different thought processes when this occurred. But can you touch a little bit on the resentencing that you had to just recently do for that young guy that we had some discussions about? I'd like you to share with the people just the outskirts of what went on and your thought process in it, because I found that very impactful. And that was the moment I knew I needed to talk to you when I heard about that.
And I believe you're talking about the case out of Grays Harbor County where the young man had murdered his parents back in 1995.
Yeah.
And this is a case that has really is happening all over Washington State to try and address the life sentence that were handed down to juveniles for, very heinous, very violent crimes. They were given life sentences, and the United States Supreme Court has determined that life sentences for juveniles is unconstitutional. And so there's a United States Supreme Court case, a series of cases, and then there's a Washington State series of cases. And the Washington State cases have been codified in the statute, and then those cases require a consideration, a 4-point consideration for how you determine the impact of the impulsivity of youth on the behavior of the child at the time as it relates to their level of culpability for the heinous crimes that they committed. And going into Grays Harbor County, you can imagine that there is not a large Black, brown, or any other community other than maybe they have a number of folks from South America down there working in some of the migrant working community. But there's certainly not a lot of Black folks down there. And this young man is white, and the family had essentially had to endure resentencing of him 4 times. This would be the 4th resentencing of this young man. So those wounds were reopened multiple times. So I had to take that into consideration. I had to take into consideration that there is a survivor, his sister, who was happened to be, by just sheer chance, not be at home that day. So the parents and the 5-year-old were murdered, but the 17-year-old just happened to not be at home, even though she was supposed to be home. She had to relive that horrific experience. This was going to be the 4th time. So I had to take all that into consideration. Now, they come from a very small town in Grays Harbor County. Grays Harbor County is, spread out wide landmass, but, sparsely populated people from an individual perspective. They come from a very small town in Grays Harbor County. So the entire community had to relive this again and again and again. And in my mind, I really could feel, just even before I went to court, I really could feel the pain that was not fully resolved. And so that's the mindset I went into this work with. And then the other side of it is that I have a lot of training and background in, the brain science, the development of youth, the impulsivity of youth, trauma as a child. I have a lot of training and experience representing folks who have different types of traumas. And so this young man's trauma, for the most part, was self-inflicted, but his parents were not really able to, in time, access enough resources to help redirect him before he had gotten to the point where he was no longer able to be controlled with a normal parental input. And you think about a community like Grays Harbor County, you think about, oh, well, it's a white community, they should have everything they need. But it's a very poor community. So access to services and resources that may have been helpful to this parent, while there were some, there may not have been enough outside of maybe the few counseling sessions that they were able to engage in. So I had to take into consideration all these things. And then we have this statute in Washington State that says this is how a judge should consider the impulsivity of youth. And I really was very, very methodical about it, you know, and going through. I wrote a 14-page oral ruling so that I made sure all the points were covered, and I made sure the community understood from their non-legal perspective why the law required me to rule the way that I did rule. I recognized the even if it was a very low probability that she was in any sort of danger, that the sister knew that I recognized her real, whether it was perceived or perception or not, is a real fear for her if her brother is released from prison. And I acknowledged the efforts of the prosecution, who really had to wrangle with how to tell this family that they were going to have to relive through this again, that the sister was going to have to testify again. Just so many pieces. And I also acknowledged the difficulty for any judicial officer, because the previous judicial officers had been reversed 3 times.
Oh.
So I really have to get it right. I really have to get it right. So I acknowledged how difficult that was, because it was very difficult. But in the end, the law did a very objective, when it put that statute in place, it did a very objective overview of just what the brain science says. You can't deny it. I mean, it's there on the screen. This is the, executive functioning. This is where this part of your frontal lobe is lighting up right here at this age, and this is how it's growing. And these are the things that can impact its ability to develop in a way to avoid a child engaging in that sort of behavior. So I had to really explain all of that stuff out, and I thought, if I don't write this out, there's because the margin of error is just too small. It's just too small. I have to make sure that I'm doing what I need to do to really honor the law, even in the end when the family doesn't feel that the law is fair, which I fully understood why they felt that the law wasn't fair. So, that is something that's happening all over the state. I don't know if there's any young people left to consider. There was a recent case out of our Supreme Court with, and my juvenile was a Caucasian juvenile, but there was a recent case out of our Supreme Court with an African American juvenile, and the majority in that case, he was 1 year older than the one in my case. The majority in that case found him to be more mature, and they didn't reverse, and they left him with a life sentence. And there was a scathing dissent from the members of the Supreme Court Justice bench that really calls out, sort of like the way the letter does, calls out some of those old stereotypes that African American youth are more mature and thus more dangerous to get relief than their white counterparts. And there's all of the correction of the wrongs over the long period of time isn't going to happen overnight. But I think as long as we have folks who are willing to be honest about what those wrongs are, the way Justice Montoya Lewis did with the reversals of some of the fishing rights that impact the Native American community, foster kid foster youth rights in under the Indian and Child Welfare Act. I mean, there's a lot. And then we recently had a civil case where Black attorneys, bondage sergeant out of Pierce County, it was I believe it was a car accident case, a personal injury case at any rate, and the white attorney for the insurance company kept injecting angry black woman stereotypes into her arguments and into her questions. She kept injecting, a freeloader, kind of welfare queen, looking for a buck kind of things into her presentations to the jury, and the Supreme Court overturned it because they gave her like, I don't know, like $900 when she should have got 200 plus thousand. I don't know what the numbers are, and I don't mean to profess that I know, but the amount of money they gave her was really more of a slap in the. It was an actual slap in the face, and the Supreme Court overturned it and really laid out what is not going to be tolerated in applying stereotypes, direct or subtle, to litigants who have been marginalized in the system. And it doesn't matter if it's a civil lawsuit or a criminal matter. They have given the judges instructions. So those are additional things that our Supreme Court has done to put forward their commitment to the message in that letter. So I feel grateful that I am on the bench at this time. Sometimes, we know in our community that the burden is heavy on our shoulders, but I think as long as we are committed to being the educators, if we need to be, and to help people really see the benefit overall to the community by addressing these wrongs head on, then I think things will get better. It just takes time, and sometimes you need a monkey wrench thrown into the system, the way our Supreme Court did with that letter. There's so many tools in it. There's just so many tools.
I like to call it, they ruffled a lot of feathers. And I like to say, when people say I ruffle feathers, you got to ruffle your feathers to fly. So I appreciate that, Your Honor. It's for everybody that's listening, I think one of the most important things that we should take from this is that the Supreme Court of Washington has stated that they will not tolerate marginalized language towards defendants. So if you hear that, that's something that the layperson can take into account and see that something is done by that. Your Honor, I appreciate you. Giving us an inside look, a bird's eye view. Your humanness and your realness is just what I thought it was, and just a very honest woman of high integrity. And she been nice, but she's a savage. I'm probably sure when she was returning. So I just wouldn't want to be on your bad side. So thank you so much for your time and your expertise and all the knowledge. I got tons of notes. And if anybody have any questions for us, we'll be sure to get them to you. And Cynthia, do you have anything you want to leave Judge Amamilo with?
I just wanted to say thank you. I really appreciate your honesty and some of the things that you said that you touch bases on. And Darryl, I want you to put that website she was talking about up on the internet so that people can go in and look at those meetings from 9 to 12. She said on which day did you say? I got it. In the month? You got that? It. Okay. Yeah. I think
all of the actual dates are on the Sentencing Guidelines Commission website.
And how can we contact you? If I wanted to contact you, how could I reach out to you?
Mr. Riley has my email, but you can, because this is part of what our job expects from the Superior Court Judges Association, is that we are connected to community, and that we are trying to make sure that the justice we are meting out is the justice that the community expects. So You can reach me at my official email, sharonda.d.amamilo@co.thurston.wa.us. And I will respond to you on these issues in the capacity that I am able.
Thank you.
You're
Well,
welcome.
thank you again, Your Honor. I really appreciate you. It meant a lot. I think you brought us a lot of credibility, a lot of warmth, solid as always. And I just appreciate you. And to everyone else who's watching, we want to ask you to continue supporting us by just liking, by sharing, by subscribing to our YouTube channel. And if you know anyone that's been through these situations, we're going to get more into that. In fact, our next week's episode, we'll have a special guest, Janelle Borderson, who's actually the one of the leadership people on the Welcome Home Project. The Welcome Home Project is a reentry project for people getting out of prison. And it's funded or founded by the Seclallam Port Gamble tribe. Make sure I get those tribes right. So she'll be our guest next week. And we'll start talking about some of those things too, because all of us know someone who continue to go through the cycle of recidivism. And we want to be able to get these brothers and sisters some tools and some resources when they get out. They could do like us and try to turn it around. And I'm just so grateful for where we are today. And I thank you again, Your Honor, and Sister Cynthia Brady. Thank you as well. See you all next week.
Thank you. Thank you, everyone. Grateful to be here.
Have a good night.
Good night.
Have a good night.
Every morning I wake up, all I know is get it. The OGs always told me what I start, I gotta finish. So I push it to the limit, so I can be the greatest. So I can look my family in their eyes and say we made it. Don't let life hand you nothing, you just gotta go take it. Always keep it 100, don't ever let me catch you faking. Keep a close eye on your circle,